Good evening, good morning, good afternoon, wherever you are. I hope you're well. Hope everybody in your family, your little circle of friends is healthy. I um I would like to spend some time and go over the court documents that I have here. Um I was going through that spreadsheet and I was looking and I'm looking at the documents, and I'm looking at the documents and it's just repetitive and it's nonstop. So, what I'm going to show you today, or actually maybe just speak, is the last filing that Karen's attorneys filed in court. It's just like a summary of where they're at in their case. Um, in America, and this is this is important. In America, if you're accused of a crime, you're allowed to look at all the evidence as well as face your accuser in court. Those are the rules. That's the way it is. Karen hasn't been allowed to look or touch any of the evidence that the state's using to convict her. Now, when I say the evidence, she's been given a couple things here and there. But let's just do this. This is what happens. And this is what the state's doing. In court, there was a picture of Michael Proctor and Jennifer McCabe's two daughters. They were in the picture. Now, the picture itself had three girls in it. And when they went to court, they said, "Hey, Your Honor, Michael Proctor is conflicted. He's friends with Jennifer McCabe." And Adam Lally gets up there. Now, mind you, Jennifer McCabe has two daughters in the picture with a third child. Lally gets up in front of the court and goes on for about 5 minutes how this is not Jennifer McCabe's kid. These two are. The picture had three children in it. The lawyers said, "Hey, judge, he's conflicted. These are Jennifer McCabe's kids." But yet in court, the judge allowed Adam Lally to stand there and cry out in court that this wasn't Jennifer McCabe's child. And guess what? He was right. These two are. This one isn't. And this is a court in Massachusetts. This is a murder trial. And the judge is allowing that to go on. The judge. Same judge who rented out her beach house to somebody that's got a very, very identical name as somebody that was at the murder scene that night. That's kind of strange. But again, I guess, I don't know, must be some awesome type of a house. That'd be, thinking about it, that'd be an absolutely wonderful way to maybe pay people off. I was thinking about it. All you got to do is have somebody rent your place for X amount of dollars. You could just do the whole Airbnb thing, People come, they rent out your place and give you money for it. And yeah, I don't know. I don't know how you're going to figure that part out, but There's resourceful people out there. Now, I'm going to read you the last filing from court because I'm not going to repeat 4 pages of Cameron's lawyers asking for evidence. They keep asking. So I'm going to it all gets summed up in this last document. So I'm going to share my screen. Okay. Maybe not. Let me do this instead. I don't like that. That right there takes stop. No, that right there takes too much in my brain. All right, we're going to do this one. Okay. This is the document, that spreadsheet. It has, let me put my glasses on here. Okay. This is the timeline that they have. I'm not going to go over that now. Here's the who's who we did. These are the witnesses and specifically what they witnessed, documents that are relevant. This is discovery, law enforcement, the questions and whatnot, communication log, in, out, who called who, blah, blah, blah. Apple Health data, raw data. Look at that. Yep. Jen McCabe, Apple Watch, 552. 230, she's up. 351, she's up. Yep. Walking around. 67 feet. She's got a phone with her too. All right, so we're gonna go back to documents, and we're gonna do the September 13th, 2023 defense, what they submitted to the court. I'm gonna read it. Let me zoom in on this. There we go. Whew. Now, I'm gonna make mistakes. I'm gonna say the wrong words. I'm gonna stutter. I think people. I heard someone say that they listen to me, and I think people are putting me on and popping their earphones in, or they had the earbuds, or just putting it on in the background and listening to what I have to say. I want to say thank you to everyone that's listening to me right now. I'm just blown away that there's anybody that would want to listen to what I have to say. But if you want to put this on and just listen to it, and things will click, things might not, never know. But again, I deeply appreciate every single subscriber. I got like 300 subscribers already, and I'm just beyond happy. I couldn't be happy. There's 300 people in the world that want to listen to what I have to say. Pretty cool. Really cool. All right. This is we'll start here. Commonwealth of Massachusetts as the plaintiff versus Karen Reed. This is filed September 13th, 2023. The defendant's reply to the Commonwealth's response to defendant's renewed motion to compel discovery and access to evidence. Okay, compel. That word compel, the definition of compel. Yeah, let's do this. Compel. They are compelling. They're asking the judge to compel the state themselves to give them the data. That it's ridiculous. This should not be. We're how long into this case? Here we go. All right. Let me just double check. Yeah. All right. Defendant Karen Reed, Mrs. Reed, or the defendant, files this reply to the Commonwealth's response to the defendant's renewed motion to compel discovery and access to evidence, in spite of the fact that this case was filed 21 months ago, and the Commonwealth, through its representative, Norfolk County Assistant Attorney Adam Lally, promised this court that lab testing of the physical evidence would be completed months ago. Mrs. Reed continues to be denied access to the most basic and critical evidence obtained in connection with this case. The Commonwealth cannot sidestep its obligation to permit the defense to inspect and independently test the physical items of evidence in a timely manner in this case, simply because the Commonwealth may have complied with some of its other discovery obligations. Okay, so ain't that something? You know, Mr. Lally goes to court and says, 3 girls in the picture, and they say that 2 are Jen McCabe's, and Adam Lally talks about the one that isn't, and that's all he does. And he's doing the same thing with the evidence. Hey, I gave you that. So let's talk about that. We're not going to talk about the stuff I've been avoiding giving you. No. But because I gave you one piece of evidence, defendants' requests numbers 1, 2, and 3 for access to and independent testing of physical evidence that has been in the Commonwealth's possession since January 2022. All right, time out. Let's see, 12 and 12 is 24. And geez, they've had this evidence in their possession for 22 months. Can you believe that? Almost 2 years they've had the taillight. They've had the taillight pieces. They've had the cocktail glass. They've had John's clothing for 2 years. They've had evidence. Almost 2 years. They've had this. They have this. They refuse to give it to Karen and her team to get this stuff tested. So let's stop for a second. The state of Massachusetts is accusing Karen Reed of hitting John with her car, specifically the taillight in her car, because that's what triggered Proctor's spidey senses here. Yeah, so the taillight that they're holding her on for murder, like, they won't let her have that. They won't let her look at it. They won't let her even test it to find out if that's even her taillight. Almost 2 years. The taillight that the state's had for 2 years. Yep. How much you bet the state has all the pieces to that taillight too? That would be funny. Yeah. All right. As set forth in the defense renewed motion to compel discovery and access to evidence, Mrs. Reed has repeatedly requested, yet been denied access to and or the ability to test the following items of evidence. 1. Request that expert be permitted to independently test 42 samples which were purportedly taken from John O'Keefe's clothing and person. Yeah. 42 samples. Now, every sample has to be tested correctly. It cannot be rushed. It can't be rushed. This is a murder trial. 42 samples. That's 42 different reports. That's 42 different types of tests. And if you look at when her trial is coming up, that doesn't give Karen much time to test the samples and then do any follow-up testing that needs to be done, let alone write the reports for the testing. And but by the way, they still haven't given her the stuff to test. So let's go to number 2. Request that the defense be permitted to inspect and independently test the 7 items of evidence which purport to be items of John O'Keefe's clothing. And 3, request that the defense be permitted to inspect the 13 items of evidence, each of which contain a varying number of taillight pieces and or taillight housing recovered by law enforcement. So they're saying here that there's 13 pieces of evidence, taillight pieces specifically. To date, nearly 2 years after the inception of this case, despite repeated requests by the defense, Mrs. Reed has been denied the ability to inspect, access, and or independently test any of these critical items of evidence. ADA Lally's opposition to this request focuses entirely on the purported policies and procedures of the Massachusetts State Police Crime Lab, rather than mandatory discovery provisions set forth in Rule 14. The Commonwealth's discovery obligations are not governed by lab policies and protocols. Let's time out. Lally, yet again, is saying State Police Lab, their policies trump me giving you evidence because the lab says so. Think about that for a minute. This guy's prosecuting Karen for a murder. Lally is saying Karen did it, and he's going to prosecute her for murdering her boyfriend, John O'Keefe. He's going to do it, right? And he won't give up any of the evidence. Isn't that strange? Isn't that odd? And you got to say, you're sitting there saying, no. They got to give you, they have to give you the evidence to test independently. Well, it's been almost 2 years and they won't give up John's clothing. It's been 2 years. They won't give up a single piece of taillight. How do we even know that taillight's from Karen's car? We don't. Hasn't been tested. Is it the same plastic that Lexus uses? What's the compound of it? What's the percentage of plastic versus filler? This gets me so ramped up. All right. Now, we're going to get into Lally, but Lally's going to try and use the lab excuse again down the road. Here we go. Rule 14 of criminal procedure clearly states the prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy each of the following items and information at or prior to the pretrial conference, provided it is relevant to the case and is in the possession, custody, or control of the prosecutor. They have it. Persons under the prosecutor's direction and or control, or persons who have participated in the investigating or evaluating the case and regularly report to the prosecutor's office or have done so in the case. Material and relevant tangible objects, Rule 14. We are long past the first pretrial conference in this case, at which the Commonwealth's mandatory obligation to comply with this rule became ripe. The purported internal policies of a crime lab do not trump Mrs. Reed's constitutional and statutory right to obtain evidence in advance of trial and prepare her defense. The Massachusetts State Police Lab protocols are of no legal moment. ADA Lally spends an inordinate amount of time discussing what the lab has done to test and retest certain items of evidence. The Commonwealth does not get to hold hostage every single item of evidence merely because the Commonwealth may have acted dilatory in testing a select few items of evidence that have been in state custody for 21 months. I am checking that word. What's that word again? Dilatory. All right. D-I-L-A. Did I spell it right? D-I-L-A. Huh. Weird. There it is. All right. Objective. Slow to act. Okay. Well, that's definitely Lally. Slow to act. How about just not acting at all? 21, almost 2 years. Wow. Notably, in the Commonwealth's opposition, ADA Lally asserts that the defense can't have access to any of the above 62 items of evidence because the following 6 items of evidence are undergoing further testing. What? Notably, in the Commonwealth's opposition, ADA Lally asserts that the defense can't have access to any of the above 62 items of evidence because the following 6 items of evidence are undergoing further testing. Oh boy. Yeah. 1. Because the following 6. Here we go. So because there are 6 items the state's testing right now. And because of that, they won't give up the 62 items because they're still testing the 6 back again to the way Lally's doing it. What a freaking genius, man. Comparative testing for items 7-18.18. Debris from an orange t-shirt and gray long sleeve shirt. And item 3-1, passenger side taillight. So they're not going to give up the orange shirt, the gray long sleeve shirt, and the passenger side taillight. They're not giving it up. Those things right there would prove Karen's innocence. DNA testing in reference to item 7-3.1. Sample from White's right instep of sneaker. Okay. 7-17.3. Sample from stain B on top of left of orange t-shirt. Stain B on top front left of orange shirt. Right hand fingernail clippings and A3 left hand fingernail clippings. I'm going to just take a quick second and I'm going to look at my spreadsheet and look for the Commonwealth's opposition. That should be down here. Defense, Commonwealth's motion. I think I found it. All right. Wow. Okay. Before I'm just going through this. I don't want to throw nonsense at you, so I'm just trying to make sense. All right. Let's go through this. Let's find out. Actually, I can come back and do this later. Yeah, that's that'd probably be tomorrow. All right, let's go back to this. Where was I? All right. Word screwed me up. All right, DNA testing. There we go. First, with regard to the comparative testing for items 7-18.18, debris from orange t-shirt and gray long sleeve shirt, item 3.1, passenger side tail light. This comparative testing will either establish that the apparent plastic is consistent or inconsistent with passenger side tail light. Either way, the result will not necessitate any further comparative testing because that will have already been done. Okay. Second, the Commonwealth asserts that they are conducting DNA testing on O'Keefe's shoe, his left fingernail clipping, his right hand fingernail clipping, and a stain from his t-shirt. This testing will only produce results having evidentiary value if the DNA profiles obtained from these items of evidence are compared to and match the individuals who were in the Albert residence that night, namely Brian Albert, Brian Higgins, Colin Albert, Jen McCabe, Matt McCabe, Caitlin Albert, Brian Albert, and Sarah Levinson, and or Julie Nagel. None of those DNA profiles are in evidence yet. So, the state's conducting DNA testing on John O'Keefe's clothing, but they have nothing to compare it to. There's no other DNA profiles out there for them to compare what they come up with. What's interesting is the fact that they're doing DNA on the shirt stain. So the shirt stain obviously is blood. It's not anything else. Otherwise, they wouldn't be doing DNA testing on it. All right. Thus, there is no harm in allowing the defense access to and independent testing of any of the remaining 56 items of evidence. The Commonwealth has sat on this evidence for 21 months. Mrs. Reed respectfully requests that this court order the Commonwealth to make available the remaining 56 items of evidence for inspection and or independent testing immediately and set a deadline to complete the testing with regard to the remaining items of evidence as statutory as required by Rule 14. Wow. Okay. This is B. We just did A. This is B. Defense requests number 4. All right, come on. Request for defense expert access to Lexus infotainment and telematic system, EDR, Lexus safety system, and airbag control module for independent analysis. As set forth in the defendant's motion to compel, Mrs. Reed has repeatedly requested that her expert be permitted to access the Lexus infotainment and telematic system, the EDR Lexus safety system, and the airbag control module in order to conduct an independent analysis. So, what they're asking for is the actual vehicle's data that it captured for that date. They're asking for that information. Defense attorney Little emailed ADA Lally to request that Mrs. Reed expert meet State Trooper Paul on September 5th, 2023, to conduct an independent analysis of the Lexus infotainment and telematic system, which was seized pursuant to a search warrant. Mrs. Reed further requested that the Commonwealth produce, in advance of that meeting, a report by Trooper Garino summarizing his data acquisition and analysis, photographs of the steps that he used to conduct his data acquisition, photographs documenting the removal of the nav unit, photographs of the infotainment and telematic system. Mrs. Reed's reconstruction expert is located out of state and requires this basic information in order to know what she needs to bring with her in order to properly analyze the evidence. Thereafter, on August 28th, 2023, Attorney Lally informed defense counsel that we cannot inspect, access, or otherwise test the infotainment and or telematic system because the infotainment system is hooked up to Burla with no way to extract information at this time. The telematic system has no recoverable data. In response to Attorney Little's request on September 12th, ADA Lally emailed Attorney Little informing her that additional information regarding the infotainment and telematics would be produced to the defense such that our expert can prepare a proposed protocol for examination of this device. As soon as the defense is in receipt of the requested information, our expert will prepare a proposed protocol for the examination of the evidence and will file it with the court. So even now, Lally is saying, nope, you cannot have any information out of the vehicle that was used in this crime, supposed crime. Like, pretty sure that's wrong, Mr. Lally. You're allowed all access to all of the data. And Lally giving up some excuse because it's hooked up to Burla? No. Nope. I have a feeling if Karen's attorney comes, gets all this, gets the infotainment system, gets all that stuff, connects it all up, you're not going to see anything. One, I don't think I'll have to check on how long does the Lexus keep the data internally. I'll have to check on that. Like, how much storage is it? How long? How much data? Like, how much can it hold? How many parameters? Stuff like that. I have to check on that. See. See. Request number 5. Request for OCME's original death certificate. Although the Commonwealth has failed to comply with this request, Mrs. Reed will seek to obtain this information independently from the city of Brockton. Okay. D. Defense requests that all handwritten notes of law enforcement be made in connection with this case, including witness interviews, notes regarding this, regarding the recovery of evidence and other investigative notes. Okay. On August 25th, 2023, the defense sent an email to Attorney Lally requesting inter alia all handwritten notes of law enforcement made in connection with this case, including witness interview notes, notes regarding the recovery of evidence, and other investigative notes. Exhibit A, August 25th, 2023, email correspondence. These notes were ordered preserved in Stoughton District Court on February 2nd, 2022. Exhibit A. This evidence is clearly relevant because law enforcement has made it a habit to wait to draft reports until this case. let me just back up, okay? When an officer rolls up to a scene, he views the scene, does what he has to do, leaves the scene. He then goes back or sits down and he has to write a report. The report states what he witnessed, what he did, and when he left. Who, what, where, when, why. All them has to be written down, memorialized in a report. It's part of the call. There is no like, wait, I'll do the report later. I guess that's different for the Massachusetts State Police. These guys are so good that they can just wait 6 months and then bang a report out. Oh, yeah. I remember talking to Sarah Levinson. Sarah Levinson said that she didn't see nothing. Send. And I was talking to, let's see, who was I talking to today? I was talking to Colin Albert today. And, yeah, he said he wasn't there. Send. Let's see, who was I talking to? I was talking to, Lucky. And Lucky said that, yeah, I didn't plow the street. I mean, you do the reports when these things happen. So I'm going to reread this because it doesn't bode well for the state police here. Here we go. These notes were ordered preserved in Stoughton District Court on February 2nd, 2022. This evidence is clearly relevant because law enforcement has made it a habit to wait to draft reports in this case until weeks or sometimes months after conducting interviews in connection with this case. Weeks or months. Habit. Wow. State police make it a habit to not write the report for weeks or months later in a murder trial. I guess that stuff isn't important. Or maybe it is. These notes constitute statements of persons of the party intends to call as witnesses, which are subject to mandatory discovery provisions set forth in Rule 14. Any destruction of these notes after allegedly being incorporated into police reports would violate Exhibit A. To date, no records responsive to this request have been produced. Now, they mentioned destruction of notes. This is what happens typically. Cop will show up, takes his thing out, starts writing all his information down, name, blah, 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 blah. He then takes those handwritten notes, sits down, and types the report. Well, let's see. Those notes are part of the report, and they're being instructed here not to destroy them and to preserve them. But yet, nothing has been sent to Karen and her team. So, Mr. Lally, who's got all the time in the world to talk about how that one child isn't Jen McCabe's, he's all the time in the world. To date, no records responsive to this request have been produced. By the way, Karen, 100% entitled to 100% of all that information. They don't have it. But they're going to prosecute her on a murder trial, yet they don't have that information. Do they have that in other trials, I wonder? When were the reports written in the other cases? Were they written like immediately? How come like Sergeant Tully allowed that to go on? Is that normal protocol for the state police to allow them not to write reports for months, years? Just whatever. Here we go. Number E. Defense request for all reports, photographs, handwritten notes, and mapping documenting the recovery of taillight pieces from 34 Fairview Road. This is what is going to kill me. It says the pieces from 34 Fairview Road. You and I assume that we're going to get pieces of the taillight. If they can find a way to say that the taillight was not on 34 Fairview, if it was on 32 Fairview, for example, the taillight was located there, the pieces, they're not going to include it. That's a Lally move. You and I are assuming they want all the taillight pieces, which is what they want. But it says 34 Fairview here. Lally, if a piece was found somewhere else, he will find a way not to include it, even though it's still part of the entire accident. All right. On August 25th, 2023, Attorney Little emailed ADA Lally requesting reports, photographs, handwritten notes, and mapping documenting the recovery of taillight pieces from 34 Fairview Road. Notably, on July 25th, 2023, the Commonwealth finally produced photographs and reports regarding the items of physical evidence that had allegedly been recovered from the Albert residence in January and February 2022. Photographs of the bags containing items of evidence, which were produced for the first time on July 25th, 2023, established that law enforcement, namely Trooper Not Conflicted Proctor, conducted at least 5 undocumented searches of 34 Fairview Road, which supposedly resulted in the recovery of taillight pieces. Time out. Proctor, lead investigator, best friends with Jen McCabe. Oh, I'm sorry. They don't know each other. Trooper Proctor went back to the scene 5 times. At least 5 times he went back to the scene. And he found taillight pieces 5 different times. Yeah. Oh, and he has no reports, no location markers, nothing, no pictures, no photographs in any way, shape, manner, or form. Now, let's talk about the taillight for a second. If that taillight was cracked when they seized the vehicle, which by all reports, it was. Absolutely, absolutely was. It was definitely cracked because she backed into John's car. If they took her taillight back to Canton Police Department and they called in, we'll just pick somebody. Officer Wantless. If they called him in to remove the taillight from the vehicle, because if, hypothetically, imagine it, you can imagine in a perfect world like this whole person will make up, Mr. Wantless. Mr. Wantless, Canton Police Department officer, they call him in, pay him time and a half. This is all just like hypothetical. He comes in, he owns an auto body shop, so he knows all these vehicles. He knows how to remove the taillight, so he does. He's instructed to remove the taillight while the vehicle is in custody of the Canton Police Department. Chief Rafferty, as a matter of fact, in your garage. Miss Rafferty, do you have footage of that night? Do you have footage of that incident? Mrs. Rafferty, do you have footage of Karen Reed's car and the taillight housing being removed? Because it's your garage, Mrs. Rafferty. Buck stops with you. Do you have that footage? So, if you were to take that housing out of the car and it was cracked, and you kept cracking it and cracking it and cracking it, and you pick the pieces up and put them in baggies, 5 different baggies, so you have evidence bags now with evidence in it, and the car hasn't left the garage. Imagine that if that ever happened. Oh, but the chief could have grabbed a couple pieces, driving by, sprinkle. Hypothetically, of course, none of that would ever happen. We're going to get those reports back, and Mrs. Rafferty's going to produce that footage that shows the taillight just destroyed. She's going to show us that. Miss Rafferty's going to show us that information. She's going to make this right. After the trial, she's going to show us all that, right? You're going to show us how Proctor took pictures of that taillight, right? In your garage, correct? With your cameras that were running. You have that footage, right, Miss Rafferty? Hope so. I hope so. So, let's go back and continue that. Where was I? I was this one. Yes. Okay. 5 searches. These searches were not referenced or otherwise documented in any reports, memoranda, or notes produced by law enforcement to date. The only reason the defense is even aware of these additional searches is because the bags that contain the taillight pieces were marked with dates on them with the pieces that were found, and then photographed by criminalists at the Massachusetts State Police Lab. So they put the pieces in the plastic baggies, and then they took the baggies to the lab to have them take a picture of the pieces in the bag, not where the pieces were found, because that's proper protocol. But the Commonwealth has not produced any documents that are responsive to this request. The requested information is subject to the mandatory discovery provisions outlined in Rule 14, which requires the production of all material and relevant police reports and statements of persons the party intends to call as witnesses. Rule 14. So I'm thinking that anything that doesn't have a picture shouldn't be allowed as evidence in court. Nothing. If it doesn't have a picture memorializing where exactly it was at that state, out. Don't even allow it. But we have a judge. I wonder if I can rent a beach house to change a ruling. Is that possible? I'll have to find out. Yeah. Like if I want a piece of evidence in, do I have to rent your house for a day? How does this work? I don't know. All right, let's go on. F. Defense request for the raw data associated with the CERT team's mapping of items of evidence recovered from 34 Fairview. The CERT team is the team that goes out and they will actually they'll take a piece of evidence and they will put it in a three-dimensional time space. They take the measurements. It's this far from the hydrant. They make the data. They create the data of the incident. If you hit a pole, they'll take the scrapings, they'll take pictures of the pole, the measurements, so stuff like that. On August 25th, Attorney Little emailed Lally requesting the raw data associated with the CERT team's mapping of items of evidence recovered from 34 Fairview Road. Law enforcement failed to take any establishing photographs sufficient to show where the items of evidence, taillight pieces, were recovered from outside of 34 Fairview Road. To date, the Commonwealth has produced a printout of a map which purports to show the CERT team's mapping of items of evidence. This printout, attached hereto as Exhibit B, is completely incomprehensible because the squares that are supposed to represent individual pieces of taillight are represented by icons that approximate the size of 3 large SUVs. As such, the defense is requesting the raw data associated with this mapping such that the defense can identify the precise location of the taillight pieces that were purportedly recovered in Brian Albert's front lawn. That's a problem. The prosecution is required to produce this information, which constitutes material and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any persons or scientific tests of experiments within the meaning of Rule 14. I have a problem. I have a big problem. There's no way you're finding taillight pieces on Brian Albert's grass. Ask anybody. If the taillight pieces were found on the grass, Karen would have had to jump her vehicle over a 6-inch curb. There's no physical way possible for the taillight to get on the grass. Her vehicle would have been airborne at 24 miles an hour. If she hit a 6-inch curb, She's going in the air. She's launching her vehicle in reverse. It'll end up in the front lawn. She'll probably have all 4 tires off the ground. She wouldn't even know it happened. There's no way you're finding pieces on the grass. No, 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 no. Matter of fact, right now, hold on. Yeah, let's do this. Yeah. Hmm. Yep. Here we go now. Here we go. Telling me it's on the grass. On the grass, huh? I can't see that. Uh, mm. Nope, not this folder. So it's yeah, here we go. Where is that one picture I took? Where is that picture? Picture. Where are you? I have a picture of the curbing at Karen's house. I don't know where it is though. All right, you gotta hold on. I'm gonna find it. Let me pause this real quick. Hey everybody, I'm back. I found what I was looking for. I I'm a little taken back. I'm in awe. I'm just in awe. So let's go here. I need to read this again because this bothers me a lot. As such, the defense is requesting the raw data associated with this mapping. They have a stick with a computer halfway, little tablet type of device, and it's made by GIS. And they go to the taillight piece and they put the pinpoint, the run piece of evidence, and it'll put that piece of evidence in a 3-dimensional space. The software does it. That's what they're looking for, the mapping, like the raw data from that you can put into the software, because the raw data will tell you that this piece was found at this latitude, this longitude, at this degrees, at this many minutes. It'll tell you all that information, and you can take that and put that into any GPS software per se, and it'll put that piece in the time space position. As such, the defense is requesting the raw data associated with this mapping such the defense can identify the precise location that the taillight pieces were purportedly recovered in Brian Albert's front lawn. Really? Brian Albert's front lawn? This is where it's ugly. See if I can show you these. Oh. Negative. It's not going to do it. Oh, come on. All right. So, share screen. I want. You ready? That, my friends, is a 6-inch curb. I measured it. If they found taillight pieces in Brian Albert's front lawn, Karen would have had to jump the curb in reverse, which would then have absolutely destroyed the front yard with the grass all over the place. The frozen grass and the dirt, everything's frozen. Her tire tracks at 22 miles an hour. At 20 miles an hour, her tire tracks on the front lawn, even driving over it, you'll see the tire tracks because it's snowing out. If she jumps the curb, you'd see where she jumped the curb. None of that was visible. Which means she didn't jump the curb, which means she didn't do it. Six-inch curb. She's going to jump a 6-inch curb at 20 miles an hour in reverse while she's drunk. And no one's going to see it. No one's going to witness the vehicle, like, jump the curb. Besides, where John was found, it doesn't, you would have to have driven on the lawn. Of course, that wasn't found. Nobody witnessed that. Matter of fact, they all witnessed her driving away that way. Wow. Wow. All right. Huh. Well, that's interesting. Let's continue. Yeah. There we go. That's bigger. Turning Elizabeth Little. Let's just, again, real quick. She's awesome. She's, I don't think enough can be said about her. She's dynamite. What an awesome attorney she is. So, Attorney Elizabeth Little, do certify that I've served the defendant's reply to the Commonwealth's opposition to the defendant's renewed motion to compel discovery and access to evidence upon the Commonwealth by emailing a copy on September 13th, 2023 to Norfolk County District Attorney Adam Lally. Okay. Oh my God. Exhibit A. This is an email from Elizabeth Little. Stoughton District Court order. Preservation of handwritten notes. I need some coffee for this one. I'm pretty sure we read this already. No, we have not. All right, there goes the email. Dear Mr. Lally, in addition to the requests detailed in my August 23rd email below, please accept this email as an informal request for the discovery of the following information. 1. All handwritten notes of law enforcement made in connection with this case, including witness interview notes, notes regarding the recovery of evidence, and other investigative notes. These notes were ordered preserved in Stoughton District Court on February 2nd, 2022. See attached. 2. Reports, photographs, handwritten notes, and mapping documenting the recovery of taillight pieces from 34 Fairview Road. For at least 5 of the searches conducted at 34 Fairview Road, we have no reports, memoranda, notes, or other information regarding the recovery of that evidence. The only reason we know about these additional searches is because the dates of the recovery are written on the photographs of the bags containing the items of evidence. So they never would have known. Wow. Good catch. Good catch. The raw data associated with the CERT team's mapping of items of evidence recovered from 34 Fairview Road, such that we can determine the precise locations of items recovered. So they want the raw data, not the data that, of course, the state police go. They put an icon where the data was found. So if you're looking at 34 Fairview and a piece of taillight was found here, they put an icon like there, so you can't see precisely the tip exactly where. They could just put an arrow with an arrow in right taillight piece 1, arrow taillight piece 2. It's usually what they do. Where are those notes? CERT's got to have them, right? CERT. Okay. And finally, oh, she's good. Finally, this is a friendly reminder that you are going to obtain and produce all information, documents, or other evidence regarding any communication between John O'Keefe and the Canton Police Department and or any other law enforcement agencies, including 911 calls, phone calls, email correspondence, and or police reports. This includes communications between John O'Keefe and the detectives referenced by Chief Rafferty at the August 8th, 2023 Canton Select Board meeting concerning drug activity in his neighborhood, which he admits was well documented. Please let us know whether you will produce the above by close of business on Monday, August 28th, 2023. Absent confirmation that your office will promptly comply with this request, we will need to add the remaining items to our motion to compel such that they can be heard by the court at our next hearing. Elizabeth Little. Yeah. What's this one? This is same thing, but yeah, these are some more items. You ready? All right. The- Elizabeth Little is asking Mr. Lally for some more things here. Okay, this is the back and forth that they do, the prosecution and the defense. And one of the things that they're asking for is the grand jury exhibits. We don't want to talk much about that. Let them do their thing. The grand jury is one thing I have faith in. Really, literally, I don't want to mess with that in any way. All right. One of the things that she's looking for, Mrs. Little, is access to an inspection of the evidence. We will address this at court, which we did. All right, the Lexus infotainment system. Our expert would like to meet Trooper Paul on September 5th to conduct at least an independent analysis of the Lexus infotainment and telematic system and the Lexus safety system, which was seized pursuant to a search warrant. There is no need for our expert to meet him at the vehicle site because, as you stated in your last email, everything of evidentiary everything of evidentiary value was already removed from the vehicle pursuant to a warrant. We also anxiously await the PDF of the raw data and a copy of the raw data itself, which was obtained by Trooper Garino from the infotainment system. Please accept this as an informal request for discovery of any written reports produced by Trooper Garino regarding his data acquisition and analysis, photographs of the steps that he used to conduct his data acquisition, photographs documenting the removal of the nav unit and photographs of the nav unit itself. Please also produce a report and photographs documenting all electronic control units and or other devices or modules removed from the vehicle, along with any printed circuit boards. Our expert will need to have this information ASAP so we can determine what devices she needs to bring with her on September 5th to complete her analysis. 4. Original death certificate. On the certificate of vital records that you provided in our discovery, it specifically states that death certificate was amended on April 19th, 2022. We want to the original death certificate. Okay. So there's 2 death certificates in this case. There's only a few things that can be modified, changed. You know, there's only a few things. Height, weight, age, gender, things like that. They all kind of stay the same. So what was changed? Why was it changed? Medical examiner seems to be consistent with changing. I think she had this problem when she was in New York. Let's see what this is. Another email. Yeah. Yep. This is just going backwards. So everything that is here, we've pretty much already been spoken about in front of it. So I read the top of it. So this is all the stuff that happened before it all combined, old discovery stuff. So what did we learn today? Well, let's see. I think we learned that she didn't jump the curb. There's no way the vehicle left the roadway. And if she didn't leave the road, that means John is 12 feet away from the road. So how does that happen? If she never went over the curb and John was found on the grass, how does that happen? She never, whether she went forward or backward, she never left the roadway. John's on the grass, 12 feet away, as a matter of fact. You could sell lemonade 12 feet away from a highway. No one's going to hit you. Karen didn't jump the curb. You would have seen it. John was beyond the curb. Makes you think about it now, doesn't it? Not possible. Unless she was going a lot faster than what they say. To move a 250-pound gentleman that's 6 foot 2 inches tall, to move him 12 feet, I don't think people realize what it takes to move somebody like that 12 feet. If I played basketball, I would have to move somebody that was playing that was 6 feet 2 inches tall, not his arms reach. I can't reach even 6 feet. They're 6 feet plus their arm length. So there's some more questions, I guess. And yet again, the only thing that can be said, free Karen Reed.